I found out my ex had forged my signature and erased my name from our home while I was still sleeping in it, so I said nothing and let the law eat him alive. I want to preface this by saying I'm not a vindictive person. Ask anyone who knows me. My mother, my co-workers, the neighbors who still wave at me from across the street, they'll all tell you the same thing. Mara doesn't start fights. Mara finishes her wine, takes a breath, and finds a better way. But sometimes life puts something in front of you that demands you become a version of yourself you didn't know existed. Sometimes you discover, while packing your own belongings into boxes in the home you helped build, that the man you trusted with your savings, your labor, and 7 years of your life has done something so calculated, so deliberately cruel, that the version of you who takes a breath and finds a better way has to sit down and get very, very organized. This is that story. Background: who we were. His name is Derek. He's 44, a civil engineer with a talent for detail, which, in retrospect, explains everything. I'm Mara, 37 now, a hospital administrator. We met at a mutual friend's birthday dinner 11 years ago, when I was 26 and he was 33, and he seemed like the most put-together man I'd ever encountered. He had opinions about wine and transit infrastructure and knew the difference between load-bearing walls and partition walls, which at the time struck me as impossibly sophisticated. We dated for 4 years before moving in together. Then, about 3 years into cohabitation, we decided to buy a house. I want to be precise about this, because precision matters now. We decided. Together. Over a kitchen table covered in printed mortgage rate comparisons and neighborhood walkability scores. We spent 8 months house hunting. We argued about crown molding and ceiling height and whether a third bedroom was worth the extra $40,000. We compromised. We found the house on Ellerton Drive, a 1940s craftsman with good bones and a backyard that needed exactly the kind of patient, stubborn attention we both believed we had in us. The purchase price was $387,000. Derek contributed $60,000 toward the down payment. I contributed $40,000. The remaining balance was financed through a joint mortgage application. Both our names, both our income streams, both our credit scores on the line. We were not married. This was a deliberate choice, his primarily, though I had come to accept it. Derek had a deeply held philosophical opposition to legal marriage that he articulated so eloquently and consistently over the years that I stopped questioning it. I loved him. I trusted him. I believed that the house with both our names on the deed was evidence enough of commitment. I believed that for approximately 6 years and 11 months. The crack in the foundation. The relationship had been deteriorating for about 18 months before it ended. Not dramatically. Derek was never a dramatic man. It was more like watching a tide go out. Slow, almost imperceptible, until one day you look up and the water is simply gone. He had stopped including me in decisions. Financial decisions, social decisions, minor household decisions. He had started spending most weekends at his brother's place upstate, or so he said. He had become distant in that particular way that men become distant when they've already made a decision and are simply waiting for the appropriate moment to announce it. That moment came on a Tuesday in March. He came home, sat at the kitchen table where we had once spread out mortgage comparisons, and told me that he thought we should transition out of the relationship. That was his exact phrase. Transition out. Like we were a business winding down operations. I was devastated. Of course I was. 7 years is not a small thing. But I was also, and I recognize how strange this sounds, almost relieved. The uncertainty had been its own particular torture. At least now I knew. We agreed to handle things like adults. I would have 30 days to find alternate housing. We would deal with the property through proper channels. He would have his attorney contact my attorney about the buyout of my equity stake. He was calm. Methodical. He even made us both tea. I cried in the shower that night, alone in the bathroom of the house I co-owned, and then I slept. What I did not know, lying in that bed, was that Derek had already been planning this for over a year. What I did not know was that the proper channels he had mentioned were channels he had already spent considerable energy reshaping. What I did not know was that by the time he sat across from me making tea and talking about transitions, the house on Ellerton Drive no longer had my name on it. It hadn't for 14 months. The discovery. I found out by accident. That's the part that still catches in my chest when I think about it. Not the betrayal itself, but the mundane accident of its discovery. I was at the county assessor's office 3 weeks after the breakup, gathering documentation for the equity discussion. My name, address, tax contribution history. Standard paperwork. The kind of errand you do on a Wednesday afternoon without any particular dread. The clerk handed me a printout. I looked at it. Then I looked at it again. The property at Ellerton Drive was listed under one owner. Derek Allen Marsh. Sole owner. Transfer of title recorded 14 months prior. I remember the specific quality of the silence in that room. The faint hum of a computer fan. The distant sound of a copier. I remember thinking, in a very calm and detached way, that I needed to sit down. I sat down in a plastic chair near the window and read the document 4 more times. Each time, the same result. My name, which had appeared on the original deed, had been removed via a quitclaim deed, a document that transfers property interest from one party to another, and recorded at the county courthouse 14 months ago. I did not remember signing a quitclaim deed. I did not remember it because, as I would eventually confirm, I had not signed one. Someone had signed it for me. Update 1. The attorney and the paper trail. I did not confront Derek. I want to emphasize this because it was the most important decision I made in the entire process, and it required everything I had. Every instinct I possessed was screaming at me to drive home, stand in the doorway of that craftsman house with its good bones and its painstaking renovations, and demand an explanation. But I sat in my car outside the assessor's office for 20 minutes, and I made a different choice. I called my friend Renata, who is a paralegal, and I asked her for the name of the best real estate and property fraud attorney she knew. She gave me 2 names. I called both from the parking lot. The first had a 2-week wait. The second, a woman named Patricia Osei, had a cancellation the following morning. I spent that night doing what I do well, organizing information. I gathered every document I had ever signed relating to the house. The original purchase agreement. The joint mortgage application. The closing documents. My 7 years of bank statements showing mortgage contributions, $1,847 per month, every month, my half of the joint payment, directly traceable, never missed. I gathered the receipts I had kept, somewhat obsessively, for every major home improvement. The kitchen renovation we did in year 3, the deck we added in year 5, the new roof in year 6. My contributions to all of it, documented. I printed everything, put it in a folder, and drove to Patricia Osei's office the next morning. Patricia was exactly what I needed. She was measured, thorough, and within 15 minutes of reviewing my documents, she said the thing I needed to hear from someone with a law degree: this is fraud. She explained it methodically. A quitclaim deed requires the signature of the grantor, the person giving up their interest. My signature, or a convincing forgery of it, appeared on the recorded document. The deed had been notarized. This meant either the notary had been negligent or complicit, or Derek had found someone willing to fraudulently notarize a signature I had not provided. Either way, she told me, we were looking at potential criminal fraud, forgery, and civil claims for the full value of my interest in the property plus damages. We were also potentially looking at mortgage fraud, since the original loan had been secured using my income and credit. What I need you to do, Patricia told me, is continue behaving exactly as you have been. Do not confront him. Do not mention the deed. Do not give any indication that you know. Continue the conversation about the buyout as if you're operating in good faith. I nodded. Can you do that? She asked. I thought about the kitchen table, the mortgage comparisons, the tea he had made me. Yes, I said. I can do that. Update 2. The investigation widens. Over the following 3 weeks, while I played the role of cooperative ex-partner in text messages and email chains, Patricia and a forensic document examiner she retained were doing the real work. The notary who had stamped the quitclaim deed was a woman named Greta Hollis, who ran a mobile notary service from her home in the next county. Patricia tracked her down. When presented with a certified copy of the deed and informed that the grantor had no recollection of signing it, Greta Hollis initially said she couldn't comment on specific documents. Then Patricia mentioned state licensing boards. Then Greta Hollis had quite a lot to say. She hadn't met me. She had never met me. Derek had come alone with a document already partially completed and had assured her that the other party, his business partner, he had called me, had already signed in his presence and simply couldn't attend the notarization. Greta had notarized it anyway, improperly and illegally, because Derek had told her it was a routine real estate restructure and he had been very confident and charming about it. She was, to put it plainly, terrified. She immediately retained her own attorney and began cooperating fully. The document examiner's report confirmed what we suspected. The signature on the quitclaim deed bore superficial resemblance to mine, but failed 7 of the 12 comparison metrics used in forensic handwriting analysis. It was not my signature. It had been carefully crafted, practiced, even, but it was not mine. Meanwhile, Patricia had filed a lease pendens on the property. This is a legal notice recorded against real property indicating that a lawsuit involving the property has been filed. The practical effect was immediate and significant. Derek could not sell, refinance, or further transfer the property while the lease pendens was active. The house was, in legal terms, frozen. He found out about it when he tried to refinance the mortgage, which, I should note, still had my name on it as a co-borrower, since changing the deed does not automatically remove you from a mortgage. He had apparently been planning to refinance into his name alone as the next step in his scheme. He called me 3 hours after the lease pendants hit. I let it go to voicemail. He called again. I sent it to voicemail again and forwarded both calls to Patricia. The text messages came next. They started measured, "Mara, I think there's been some kind of administrative error with the property, can we talk?" And then grew progressively less measured as the day continued. By evening, he had moved from confusion to irritation to something approaching panic, and the progression told me everything I needed to know about how calculated this had all been. Innocent men don't panic like that. Innocent men ask questions. Guilty men try to reframe. Patricia drafted a formal response that evening. It was 4 sentences. It informed Derek that I was represented by counsel, that all future communication should be directed to her office, and that I was aware of the unauthorized transfer of the title and the fraudulent execution of the quitclaim deed. The 4th sentence told him that both the district attorney's office and the state licensing board for notaries had been notified. I proofread it. I told Patricia it was perfect. She sent it at 9:47 in the morning on a Thursday. Update 3. The Unraveling. The weeks that followed were a masterclass in watching someone realize they have underestimated you. Derek retained an attorney, a man named Clifford Baines, who I had heard Derek mention before as a sharp guy, someone from his professional network. Clifford Baines sent 2 letters in the first week, both attempting to characterize the title transfer as a mutual agreement reached during a period of relationship difficulty that had simply been improperly documented. This is a remarkable construction. It suggests that I had agreed to sign away my interest in a $387,000 property but had just, apparently, forgotten to do it myself and hadn't mentioned it to anyone. Patricia shredded both letters in her response. What was happening on the other front, the criminal side, was moving on its own timeline and with considerably more gravity than Clifford Baines's letters. The district attorney's office had opened a formal investigation. Fraud. Forgery. The specific charge of using a fraudulently notarized instrument to deprive someone of property rights. These are not minor things. These are felonies. Derek was interviewed. I know this because his sister, Dana, called me. Dana and I had always had a complicated relationship. She was loyal to her brother in the reflexive way that siblings sometimes are, but she was also a fundamentally decent person who I had shared holidays and long dinners with for 7 years. She called me on a Saturday morning and asked if I would talk to her. I spoke with Patricia first. Patricia said I could speak with Dana, carefully, as long as I understood that the conversation might be relayed to Derek. I understood. I spoke with Dana carefully. She was not calling to defend him. She was, I think, genuinely trying to understand what had happened. Did he really do this? She asked me, and the rawness in her voice was real. Did he actually forge your name? I told her that I hadn't signed any document transferring my interest in the property, and that the forensic examination of the signature had confirmed it wasn't mine. There was a long silence. Then Dana said, "I don't know him anymore." I didn't say anything to that. There wasn't anything to say. What I learned from Dana, carefully, only what she offered voluntarily, was that Derek had been planning the property transfer for at least a year and a half. He had consulted with Clifford Baines during the relationship, before the breakup, about how to structure a separation that would minimize his financial exposure. Clifford, to his apparent credit, had told Derek that a proper buyout of my equity was the only legal path. Derek had then, apparently, decided to find a different path. He had also, Dana told me with a voice that had gone very flat, been seeing someone else for approximately 14 months. Since roughly the same time the quitclaim deed had been filed. I had suspected. I hadn't known. Knowing didn't change the legal calculus, but it clarified the timeline considerably. He had transferred the title around the same time he had begun planning an exit, around the same time he had begun a new relationship, and he had done it 14 months before he sat at our kitchen table and made tea and told me we were transitioning out. He had been living with me in a house he had already stolen. For over a year. Making tea. Talking about transitions. Update 4. The resolution takes shape. The civil case and the criminal investigation ran parallel, and while I had no control over the criminal timeline, the civil case moved on our schedule. Patricia filed a formal complaint in civil court seeking restoration of title to joint ownership, recovery of my $40,000 down payment contribution with interest, recovery of my 7 years of mortgage payments, calculated at $155,148 total, recovery of my documented contributions to property improvements, $23,400, and punitive damages for the fraudulent execution of the title transfer. The total figure Patricia put in that complaint was $241,872. Derek's attorney tried to negotiate. He sent a settlement offer of $65,000, my down payment plus a nominal additional amount, in exchange for dropping all claims and cooperating with a criminal investigation to suggest the title transfer had been mutually understood if improperly executed. Patricia's response was brief: declined. The second offer was $110,000. Also declined. During this period, several things happened that shifted the landscape further. First, the mortgage lender, who had been notified of the fraudulent transfer as part of the legal proceedings, conducted their own review and determined that Derek had violated the terms of the loan agreement. The mortgage had been approved on the basis of 2 incomes and 2 creditworthy borrowers. Unilaterally removing one borrower from the property while remaining on the joint loan was a default trigger. The lender issued a formal notice and began their own proceedings. Second, Derek's employer, an engineering firm where he had worked for 9 years, learned about the criminal fraud investigation. Engineering firms, it turns out, are quite sensitive about having licensed engineers under felony investigation for fraud. He was placed on administrative leave. Third, Greta Hollis, the notary, entered into a formal cooperation agreement with the district attorney's office. Her account of Derek's representations to her, that I had already signed in his presence and couldn't attend, was now on the record. This is not a small thing when you're building a fraud case. Clifford Baines reached out to Patricia directly, colleague to colleague. I don't know exactly what was said in that conversation, but Patricia's summary to me was, he's scared, and he should be. The third settlement offer came 2 weeks later. $195,000, which covered my down payment, my 7 years of mortgage contributions, and my improvement contributions with interest, plus a lump sum for damages. I asked Patricia what she thought. I think you could get more at trial, she said. I also think trials are unpredictable, expensive, and emotionally taxing. I think this number is close to whole. I think the criminal investigation will proceed regardless of what you do civilly. She paused. But I also think you should know that accepting a civil settlement does not obligate you to provide any favorable characterization of events to the criminal investigators. Whatever you know, you continue to tell truthfully. I took the weekend to think about it. I accepted the settlement on a Monday morning. Final update, aftermath and what remains. The civil settlement was finalized on a Thursday afternoon in June, 4 months after I had sat in a plastic chair in the county assessor's office and read a document that didn't have my name on it. The $195,000 was deposited into my account within 15 business days. I sat with a bank confirmation for a long time, not because of the money exactly, though the money was real and significant and mine, but because of what it represented. 7 years. $40,000 I had handed over in good faith. 84 months of mortgage payments. The kitchen renovation where we had argued for 3 hours about cabinet hardware. The deck where we had sat on summer evenings with wine, talking about the future. All of it had a number now. That felt both reductive and correct. The criminal case did not close with the civil settlement. Fraud charges, once submitted to a district attorney's office, don't belong to the victim. They belong to the state. Derek was formally charged with 2 counts of fraud, 1 count of forgery, and 1 count of filing a fraudulent instrument with the county recorder. His arraignment was reported in the local paper under a headline so mundane it almost made me laugh. Local engineer faces fraud charges related to property transfer. As of this writing, the case is pending. I've been told to expect a plea agreement rather than a trial. Clifford Baines, whatever his faults, is not going to let this go to a jury. Greta Hollis, the notary, lost her state license. She received a significant fine and a period of probation. I don't have particular feelings about Greta. She was careless and legally negligent, and she is facing the consequences of that. I hope she learns something. Derek was not reinstated at his firm. He is, to my knowledge, doing consulting work. The new relationship, the one that had apparently been running concurrent with our final 14 months together, ended, according to Dana, shortly after the criminal charges were filed. I don't know the details of that and I don't need them. Dana and I still talk occasionally. She sent me a text on my birthday in September. It said, "Hope you're doing something good today. You deserved better." I replied with a heart and left it at that. What I want people to take away from this. I've been sitting on this story for a while, writing it in pieces, because I wanted to tell it correctly. Not to be cruel. Not to perform my own pain for strangers on the internet. But because when I was sitting in that plastic chair at the assessor's office, I would have wanted to read something like this. I would have wanted to know that it could be handled. That there was a path through it. Here is what I learned. Document everything. I had 7 years of bank statements. I had renovation receipts. I had the original purchase documents in a folder because I am constitutionally incapable of throwing away important paperwork. That paper trail was not incidental to my case. It was the case. Every dollar I recovered was recoverable because I could prove it had existed and where it had gone. Do not confront. This is the hardest thing. Every cell in your body will want to stand in a room with the person who wronged you and demand that they explain themselves, that they see what they've done, that they feel something. What that confrontation actually does is warn them, give them time to prepare countermeasures, and potentially complicate your legal position. The best thing I ever did was say nothing and call an attorney. Cohabitation law is genuinely complicated. I am not a lawyer. I cannot tell you what your specific situation looks like in your specific jurisdiction. What I can tell you is that the assumption many people carry, that 7 years and $40,000 will protect you the way a marriage certificate would, is not automatically true. Get legal advice before you combine finances with someone outside of a formal legal structure. Ideally, draft a cohabitation agreement. Yes, it's uncomfortable. It's less uncomfortable than this. The system is slow, but it works. For months felt like forever while I was living it. In the context of what had actually happened, a carefully planned, methodically executed scheme to deprive me of my property interest, 4 months is not very long at all. I got back what was mine. The person who took it is facing criminal charges. The notary who helped him lost her license. The machinery of consequence, once set in motion, moves. You do not have to perform victimhood to be believed. I was calm in meetings. I was organized. I maintained a professional demeanor throughout depositions and interviews and difficult conversations. Some people seemed slightly surprised by this, as if a woman who had been defrauded out of her home should present differently. The calmness was not a performance. It was strategy. It was also, honestly, a way of protecting myself. The moments I cried, and there were many, happened privately, on my own time, in spaces where I could afford to fall apart. The rest of the time, I took notes. I'm renting an apartment now, on the 4th floor of a building downtown, with large windows and good light. It's smaller than the house on Ellerton Drive. There is no backyard, no craftsman woodwork, no deck where you can sit in the summer with a glass of wine. I have come to love it unreservedly. There's something clarifying about a space that is entirely yours, that no one else's claim or plan or deception lives inside of. I put what I wanted on the walls. I bought the furniture I had always liked and Derek had always vetoed. I established, for the first time in 7 years, a home that is mine in every sense of the word. The $195,000 is sitting in a high-yield savings account while I decide what to do with it. Part of me wants to use it as a down payment on something new. Another part wants to let it sit for a while and simply be mine, accruing interest, belonging to no one else. There's time to figure it out. I'm 37. I have good bones. TLDR, discovered X forged my signature on a quitclaim deed to steal my half of our shared home. Got an attorney, filed a lease pendens, cooperated with criminal fraud investigation, and settled for $195,000 while he faces felony charges. Document everything. Don't confront. Get a lawyer. ETA, for everyone asking, yes, I did get a forensic document examiner. Yes, the signature analysis was admissible. No, I don't recommend trying to handle property fraud without an attorney. Yes, I'm doing okay. Thank you.